So welcome back from the lunch break to our third panel on free movement. I'm very happy, honored. We were lucky to have two excellent speakers on the topic here. The first one only joins us, or is able only to join us online. She's a former colleague from Vienna University who has, from my perspective, I believe not from your perspective, sadly left us for the Vienna University of Economics and Business, and that is Professor Julia Tolt, who has been professor of civil law and corporate law since 2020 at the Vienna University of Economics. And she has been a number of other places too, including the London School of Economics, where she was a visiting fellow. I'm not sure, 2015, a while ago. So you bring in firsthand UK experience to your topic. Your focus is, of course, not Brexit or EU-UK relations. Your focus is on corporate and company law, where I think it is fair to say that you're one of the leading experts in Austria on that topic today, and your expertise is evidenced by the fact that you're required only to join online because you were booked by two conferences on the same day, and we're all the more grateful that you made room to jump in and also participate in this conference. Welcome very much, dear Julia. We're happy to have you. And we look forward to your presentation. Before that starts, however, our second speaker is Dr. Emilija Leinarte, who is assistant professor and co-director at the University of Cambridge, co-director at the Center of for European Legal Studies. She has been with Cambridge University also for quite a while, essentially since your PhD, and has moved up the ranks in that university. And also she is an expert and the best placed person that we could have found on the international EU law overlap or relationship, especially in the area of free movements and citizenship. She has also published widely on the subject of free movement of persons and migration in relation to Brexit, including not just, but also with together with Catherine Barnard. And this is also the topic, or that publication and the publication surrounding it will also inspire or form the topic of your presentation today, which will be the second presentation on free movement of persons under the post-Brexit regime. With that, I would invite you, dear Julia, to start with your presentation, and then, as we have practiced before, immediately continue with Dr. Leinarte's presentation, and then have a joint discussion. Julia, you have the floor, or the screen, rather.
Thank you very much for the kind introduction. I'm very honored to be able to speak on this conference, and I'm very sorry I can't be at site at the Vienna University. It's just I had a time frame of 2 hours between my speeches, and it would have taken me 3 hours to come to Vienna, so it had to be the online option. My topic is freedom of establishment and company law after Brexit, with a special focus on UK companies. And I have a plan for the next 25 minutes. After a short introduction, I want to have a closer look at the freedom of establishment first, as we understand it within the European Union, thus look at the regime within the EU, and then ask if possibly the trade and cooperation agreement between the UK and the EU might entail some right of establishment for foreign companies, either of the UK or of the EU. If that's not the case, the qualification of foreign companies is decided upon by private international law regimes of member states. And here I want to start with general remarks and then take a closer look at member states that follow the incorporation of statutory seat approach, and then go on with the real seat, with member states that follow the real seat approach, and then ask what does those, ask the questions, what consequences have those different approaches for foreign companies, for example, for UK companies that want to establish within the European Union, and vice versa. If we have time, which is likely not the case, I will focus on on bilateral international trade agreements. And then finally, I want to conclude with a summary. After the Brexit, British companies are foreign companies from an EU law perspective, and also from a member state law perspective. And the applicable law for two foreign companies is decided upon the private international law of the member states, and especially the lex societatis that applies. And the lex societatis refers to a legal order, and that this is decided upon the private international law regime of the forum state. We differentiate between two systems, the real seat approach and the incorporation of statutory seat approach. I will come back to those different approaches later on. Within the European Union, the interpretation of the freedom of establishment by the European Court of Justice came to the conclusion that this freedom also entails a right to a primary establishment within the European Union, as long as a company is recognized by one member state of the European Union. Those companies are EU companies, and if the home member state recognizes its existence, host member states have to do so as well. That's basically the regime within the European Union that overrode the private international law regime of member states. After Brexit and a transition phase until the end of December 2020, thus since January 2021, companies that are created under the law of the UK are foreign companies from the perspective of EU member states. And the question that arises is, if the trade and cooperation agreement that was provisionally enacted starting from January and then finally starting from May holds for any right of establishment for EU foreign companies from the UK perspective and UK foreign companies from the EU perspective. And what are the questions I want to address in the speech? How do we deal with UK companies that have their real seat in the European Union and vice versa? And is it possible to establish or set up a secondary establishment like an agency or a branch within the EU or respectively the UK? Now I want to focus on the regime within the European Union and start here with the freedom of establishment as enshrined in Article 49 of the Treaty on the Functioning of the European Union. And by that provision, or by that freedom, EU companies have a right to establish freely within the European Union. What constitutes a European company? That's basically a company that is constituted under the law of a member state and has its registered office or its central administration or its principal place of business in the European Union. Other companies or foreign companies are not covered by the freedom. If a company is covered by the freedom of establishment, it has a right to be treated similarly to domestic companies of EU member states. It is entitled to set up agencies and branches within the European Union, as well as subsidiaries, and a host member state must not restrict or this right to freely establish or require additional requirements. The European Court of Justice has interpreted and thereby specified the content of the freedom of establishment. Starting with the Daily Mason and the Cartesio case, it basically said as long as a company is recognized by a member state of the European Union, other member states, as long as it's recognized by a member state, it is subject to the freedom of establishment, meaning if a member state does not recognize a company as a creature of its law, then that creature is not subject to the freedom of establishment. In the Danish Centros case, the German Überseering case, and the Dutch Inspire Art case, the European Court of Justice basically held this, that member state must not disregard EU companies if they are recognized by another member state, and that it is irrelevant if this EU company wants to set up its real seat in a host member state, as long as the home member state still recognizes its legal personality. Thereby, the freedom of establishment overrode private international law regimes, which means the freedom of establishment within the European Union contains a right of a primary establishment, and also extends to pseudo EU foreign companies. That's obviously a perspective of member states that follow the real seat approach. The ECJ has also specified the content of the freedom of establishment with respect to cross-border reorganizational measures of EU companies. In civic system, it addressed the cross-border merger, invalid a cross-border conversion. In Polbert, it basically said that the member state must not hinder a domestic company to convert into a company of another member state if the other member state allows it to do so. And in Kornhaus, it only said that it's not a problem with respect to the freedom of establishment if a member state applies domestic company law rules that address issues in the vicinity of insolvency. This kind of freedom of establishment only applies to European companies, but of course, if a UK company decided to establish a subsidiary within the European Union, that subsidiary would be a European company and be entitled to the European freedoms, and thus also to the freedom of establishment. Now I want to look at the trade and cooperation agreement that was concluded between the UK and the EU to regulate their business relationships after the Brexit. We have scholars, especially from Germany, that would come to the conclusion that this treaty contains a right of UK companies and EU companies to establish freely. They basically refer to Article 128 and Article 129. You should find those articles in the fact sheets or in the handout I prepared for this speech. Article 128 basically holds a provision that grants mutual market access and forbids certain restriction. It obviously does not contain a right to establish freely. Also, Article 129 does not contain a right of free establishment. It holds a national treatment clause for covered companies with respect to the right of establishment. The question then arises: what are covered companies? And that's basically regulated in Article 124. And according to that provision, covered companies are companies that engage in substantive business operations in the territory of the state of their constitution, which means for EU companies, they have to engage substantive business operations in the EU and vice versa for UK companies. Knowing that typically pseudo-UK companies are not covered by the trade and cooperation agreement, meaning that a company that is constituted upon the law, for example, of the UK and has its real seat within the European Union. The question that is not that clear as of now: how do we deal with UK companies with a real seat in the EU that still conduct substantive business in the UK. And some would come to the conclusion that they have to be recognized as companies within the parties, by the parties to the agreement. I do have some sympathy, but I also see that Annex 19 and its point 10 point to the opposite. It says that UK companies are not granted equivalent rights to EU companies as set forth in the freedom of establishment. I will have to think about the question in the written paper a bit deeper. I'm not entirely clear as of now. But of course, I can find generally that the Trade and Cooperation Agreement grants no general right to establish freely covered companies and try the right to be treated equivalently to domestic company with respect to a right of establishment. Thus, the Trade and Cooperation Agreement does not generally overwrite private international law regimes. Possibly covered companies have to be recognized by the parties to the agreement, and those are companies that have a substantive business operation in their own country, meaning UK companies in the UK and EU companies in the EU. In any case, covered companies typically do not entail pseudo-foreign companies, because pseudo-foreign companies have their real seat, for example, in a member state of the European Union and is only registered or incorporated in the UK. How do we deal with those pseudo foreign companies or foreign companies based on the private international law regimes of member states? I want to start with a few general remarks. After Brexit, I have made that point clear. UK companies are foreign companies, but the legal status of UK companies is not longer assured by the freedom of establishment. It's private international law regimes that apply. And I've already said that those regimes are different. We differentiate between the incorporation or the statutory seat approach. Most member states nowadays of the European Union follow this approach. And then we have like the real seat approach, and only a diminishing part of member states, I will come back, who those member states are, follow this approach. Then we see mixed approaches or unclear approaches. I do not want to address the complexities of these member states in this speech. I rather want to ask what are the consequences for UK companies with a real seat in the EU. And those companies are addressed as pseudo-UK companies or pseudo-foreign companies in member states that follow the real seat approach. I've already made clear that subsidiaries that are constituted under the law of a member state are EU companies and are thus subject to Article 49 of the Treaty on the Functioning of the European Union. Private international law regimes of member states that follow the incorporation or the statutory seat approach value the private autonomy of shareholders. They are like societatis, basically refers to the legal order under which a company is constituted. Those provisions are typical transmission provisions, and that means that a company is a foreign company if the foreign legal order recognizes its legal personality, which means UK companies are recognized by EU member states following the incorporation or the statutory seat approach, as long as they are recognized by UK company law. And since the UK follows the incorporation approach, it just recognizes EU companies as such, as long as a member state recognizes their companies as a company of that member state. And with respect to a secondary establishment of an agency or a branch, the right just depends whether they are covered companies, then they are granted national treatment based on Article 129 on the Trade and Cooperation of the Trade and Cooperation Agreement. And if they are not covered, they are likely subject to restrictions. It's possible that member state restrict the access to a secondary establishment with respect to non-covered companies. Now I want to focus on private international law regimes of member states that follow the real seat approach. Those private international law regimes focus on the social interaction of the company with its surrounding area, and the lex societatis refers to the law that is applicable at its real seat. And we do not really, the concept, let's say it differently, the concept of real seat is not entirely clear. The only thing that's clear that it refers to something real as a connecting factor, either the central administration, that's possibly the place where the board meetings take place, or the principal place of business. Typically, real seat provisions or private international law provision that contain a real seat clause refer globally to another legal order, but which does not have any consequences for the topic at hand. A company thus is only a foreign company for a member state following the real seat approach if it has its real seat in the territory of another legal order. Thus, a company that is only constituted under the law of another state, let's refer to that state as the home state, and that has its real seat in the territory of the host state, is only a pseudo-foreign company for the host member state. And that means that it is domestic company law is applied, which means it is a domestic company, and we have to ask the question if the company, the pseudo UK company, fulfills the national requirements for a company. If those requirements are not met, the company is likely requalified and transposed into its national closest equivalent for which the requirements are met. For example, in Germany and in Austria, this would be partnerships. Of course, it goes along with a personal liability of shareholder. In Germany, that's only possible if the company has more than 2 shareholders. In Austria, the Austrian regime is quite strict. It requires companies and partnerships to be registered with the company registry. And if a company does not fulfill that formal criteria, it's only requalified into a partnership that has no legal personality. We call that a gesellschaftsbürgerlichen Recht. And the shareholders basically are the universal successors of the company, and then they are also personally liable for the debt of the company. Which means UK companies that have a real seat, their real seat in a member state of the European Union that follows the real seat theory might really have problems. And we have cases that deal with that problem and basically requalify those companies into national partnership, either a partnership that has legal personality or not. And then finally, the other way round, does the UK system have a problem with EU companies? I have already made that point clear. No, since the UK follows the incorporation theory, companies that are formed according to the law of a member state that follows the real seat theory are recognized by the UK, but it's unlikely that those countries allow their companies to transfer their real seat to another, or into the territory of another legal order. I want just to take a closer look at which countries still follow the real seat approach. That those are the red ones, those are the ones that could cause problem. It is basically France, but France seems to be on the brink of changing its system. Germany and Austria and Greece as well. So basically only those 4 countries, others like Portugal and Italy follow a mixed approach, and some are unclear. I have also put them into a table. The real seat approach is only followed by Austria, France, Germany, and Greece. With respect to these companies, it makes sense to us, possibly they entered into a bilateral trade agreement that could recognize foreign UK companies and override their national private international law regimes. In Austria, we possibly have such an agreement that dates from 1925. It contains in Article 15. Some scholars, especially Professor Bachner, would argue contains a mutual recognition clause. Against this backdrop, I want to conclude, since January 21, the UK companies qualify as foreign companies from a member state or a EU law perspective. Thus, the freedom of establishment, as enshrined in Article 49 and the subsequent articles, does not cover UK companies. The mutual recognition is thus not subject. Thus not subject to the European freedom of establishment. It's determined by national private international law regimes if trade regimes regulating the mutual recognition of companies do not exist. And I've already said that the trade and cooperation agreement between the EU and the UK does not entail a general right of establishment, but it includes a national treatment clause with respect to the right of establishment for covered companies. This right does not cover typical pseudo-UK companies, possibly companies that have substantial business operations going on in the UK and vice versa have to be recognized. That's the open question. But besides that, member states or parties to the agreement do not have to recognize the companies of the UK or vice versa of the UK, the EU based on that agreement. That's kind of a precondition that private international laws recognize a company. The recognition of the UK companies without a substantive business or depends on private international law regimes of the host member state. Maybe it's not even relevant if they have substantive business in the UK, then it generally depends on private international law regimes. And if the host member state follows the incorporation or statutory seat approach, then there arise almost no problems with respect to a secondary establishment if they are covered companies, that they are granted equal treatment based on Article 129 of the Treaty of the Trade and Cooperation Agreement. And if they are not covered companies, they might face restrictions. And then finally, with respect to member states that follow the real seat approach, that's basically, we've heard Austria, Germany, still France and Greece. Those member states would apply their own domestic law to companies that are created or formed due to in the UK and have their real seat in the EU. And those are basically Austria, France, Greece, and Germany. And those in these countries, the UK companies would be transposed into most likely a partnership. Thus, in this very case, UK or pseudo-UK foreign companies face the danger of being requalified into a partnership that goes along with personal liability. And here I come to my end, and thank you for the attention.
Thank you very much, Julia, for this extremely dense and interesting presentation. I suggest we immediately move on to the next presentation by Dr. Leinarte on the free movement of persons. Wherever is the camera on the sieht man die Vortragenden am Tisch? Ja. Johannes? Ja, oder? Yeah, you stay put. Do you have slides?
Yes, I do. Thank you. Hello, everyone. It is a real pleasure to be here in beautiful Vienna. Thank you very much to the organizers for the invitation. And I'm going to talk about mobility of persons in the post-Brexit EU-UK relationship, or as they like to say it in the UK, UK-EU relationship. And I'm going to rely on the research that I've been conducting with a colleague of mine at the University of Cambridge, Professor Catherine Barnard. I hope the organizers will not mind that I have slightly tweaked the title of my presentation to show that instead of talking about free movement of persons post-Brexit, I'm in fact talking about no free movement of persons. And I will start with pre-Brexit times in the UK. Prior to Brexit, UK had a two-tier immigration system. First, there were the EU free movement framework rights for citizens of the EU. And second, there was this general controlled skills-based migration for the rest of the world. Now, post-Brexit, mobility rules have resulted in a three-tiered or layer system of rights in the UK. So the tier one consists of those enjoying free movement rights under the EU settlement scheme. Tier two are those covered by the EU-UK Trade and Cooperation Agreement. And tier three is again those this general immigration control skills-based regime. And I'm going to talk about the first two categories, the first two tiers, that is the EU settlement scheme and the immigration under the TCA or mobility, and which of these two systems of rights applies to a particular person depends on actually, to a large degree, when he arrived to the UK. And I'm not going to talk about the general immigration rules that those in the UK are subject to the UK domestic rules, and in the EU, depend on the national rules of each member state. And the purpose of my talk is to provide some critical assessment of this new mobility regime and to compare it in some ways to the free movement framework under EU law. Now, the first category, as I have mentioned, are the free movement rights under the EU settlement scheme. And the purpose of the scheme is to protect the EU citizens' rights. These rights are provided in the EU-UK withdrawal agreement, which came into force on the 31st of January 2020. And this is the date, of course, when the UK ended its relationship with the EU. Now, what may be regarded as somewhat surprising is that while immigration was one of the major points of debate during the Brexit referendum, reaching an agreement with the EU on the protection of citizens' rights proved easier or faster than we might have expected. Citizens' rights were subject to an early agreement in the Article 50 withdrawal negotiations. This was insisted by the European Council, which basically stated, if I understand it well, that withdrawal agreement negotiations won't proceed as long as citizens' rights are not protected. And this was something that the speakers in the first panel also emphasized, perhaps not in the same language. And these rights are now found in part 2 of the withdrawal agreement. I will not go into detail about the EU settlement scheme and how it applies and all the different requirements. This is generally rather well known. Instead, I will just provide a brief overview of the scope of application of EU settlement rights. So the withdrawal agreement is limited to the protection of the rights already acquired by UK nationals and EU citizens prior to the UK's withdrawal from the EU and during the transition period. So this is not about future rights. There are no onward free movement rights under the withdrawal agreement. To clarify who are those who have acquired rights before the UK's withdrawal, those are EU citizens legally residing in the UK prior to Brexit and during transition period and the same is reversed for the UK citizens and their family members. So rights of these persons are protected through the EU settlement scheme, which began in March 2019. And also to point out that it covers not only EU nationals, but also nationals of the European Economic Area and Swiss citizens. The statistics are positive. Out of 5.83 million of people who have applied to the scheme, nearly 5.4 million were granted the status rights under this scheme. Now, the purpose of the scheme is to essentially ensure continuation of residence rights, and those who are covered by the scheme will retain their residence rights as are provided in the EU law and the Citizens' Rights Directive. Now, what is rather interesting is the fact that while these rights are depending on the person arriving to the UK before the end of transition period, this policy did not result in any increased migration to the UK during that time. And in fact, the opposite has happened. EU net migration has been falling since 2016. Now, those with permanent residence were able to acquire settled status under the scheme, as those under the Citizens' Rights Directive would normally do. And those without 5 years of residency, which is necessary to acquire permanent residence, were able to apply for a pre-settled status, which can be upgraded then to the settled status after 5 years of continuous residence. Now, the requirement to apply for a change of status from pre-settled to settled, or else the pre-settled status will expire, is currently being challenged before UK courts, something that you have also mentioned in the earlier presentation. And there are also rights of family members that come with this, those who were already in the resident in the UK before the end of the transition period, but also those who were not residing. Now, in terms of content of these rights, as I say, this follows the Citizens' Rights Directive. The UK has agreed to bind itself to the principle of non-discrimination with respect to the treatment of citizens, which is a fundamental principle within the EU free movement framework. Though from the Fratilla case law saga, which some of you may know, we now know that those with pre-settled status cannot rely on the treaty non-discrimination provision in Article 18, but only on Article 24 of the Citizens' Rights Directive, which imposes additional conditions. There's also social security rules that apply. I believe you've also mentioned that briefly in the context of this scheme. But again, all of this applies only to a very narrow group of persons. So the protection of citizens' rights under the withdrawal agreement may be seen as somewhat artificial extension of a personal and territorial scope of free movement rights under EU law. So in terms of the contents of the settlement scheme, it replicates the free movement framework. So in one sense, the EU can be seen as the winner here. It achieved the protection of citizens' rights, but again, and this is an important but, it applies to a limited category of persons. And as I will discuss in a moment, everybody else, for them, free movement of persons is over. Before I move to mobility rights under the TCA, just a quick note on the enforcement of citizens' rights under the withdrawal agreement. Here we can see another win, perhaps, for the EU, if you wish. The jurisdiction of the Court of Justice, which was one of the most contentious issues, again, during the Brexit debates, is present under the withdrawal agreement. So this is limited. So in this limited sense, the UK did not deliver on its pledge to fully end the jurisdiction of the Court of Justice. But that role is, of course, limited. Here I have a slide. Of course, it's very busy, as all my slides will be, but this is just to give you an indication that the green boxes indicate the elements of where and ways in which the CJEU has retained its jurisdiction. So, for example, the ECJ retains its jurisdiction for a period of time for the interpretative authority in the context of the application and interpretation of citizens' rights. There is also jurisdiction of the ECJ to issue preliminary rulings on EU law questions. So this was, of course, a major point during the negotiations. We are all aware how sensitive the EU is about the ECJ retaining exclusive jurisdiction over interpretation of EU law. As for the interpretation of the withdrawal agreement itself, this is subject to an arbitration mechanism, which resembles WTO dispute settlement body with similar system of remedies to those that we see under WTO. And just one final point on that, the withdrawal agreement is a typical international treaty in that for those who are covered by the citizens' rights, the principles of direct effect apply and primacy, which means that they can challenge violations of their citizens' rights under Part 2 of the withdrawal agreement before domestic courts, including the UK courts. Now, moving on to the rights for those citizens living in the UK and those UK citizens arriving to the EU post-transition period, mobility provisions under the Trade and Cooperation Agreement will apply. So a new system for those people. Now, here is where we see that the UK's withdrawal from the EU has resulted in a fundamental change in the architecture of the EU-UK relationship. And the UK's pledge to end free movement of persons post-Brexit has really been delivered by the UK negotiators and the government. Free movement ends both for EU citizens and UK nationals. The TCA cements the transformation of this EU-UK relationship from one of union of states tied by a common supranational citizenship to that of economic cooperation. Mobility regime under the TCA reflects this new dynamic. There no longer exists a standalone right to move. Instead, mobility is a composite part of trade. So trade-related mobility is not new in international relations. In fact, it is a global right, almost global. The World Trade Organization establishes limited mobility rights under the General Agreement on Trade in Services, GATS. So a question arises, does the new EU-UK mobility framework under the TCA provide more generous mobility regime if compared to the WTO, or given their proximity of these two partners, or is it merely reestablishing what is available under the WTO, or is it somewhere in between? Well, it is well known that WTO rules under the GATS provides for 4 modes of service supplies: cross-border supply, when a service is supplied from one country to another; consumption abroad, when the consumer of service travels to another country; commercial presence, this is about investing in a foreign country; or presence of natural persons, mode 4, where the service provider moves to another country to deliver the service. Now, the 4th mode, when natural persons travel to supply a service in another state, signifies trade in services through presence of natural persons. That is, persons who are either service suppliers themselves, or who work for a service supplier, or who travel from one state to another to provide the service. So mode 4 does not cover those seeking access to employment. This is only a temporary provision of services, not a route for permanent immigration. This makes GATS essentially different to the free movement regime, of course, under EU law that is enjoyed by the EU nationals within the EU. So mode 4 mobility is typically provided in the EU's new free trade generation, new generation free trade agreements, such as CETA or EU-Japan economic partnership agreement. So this is something that we see normally. But now going back to the TCA. Well, the TCA is an association agreement, but the trade chapter looks like a free trade agreement. The TCA does not, as I said, contain a self-standing mobility chapter. This is despite the fact that the original EU draft proposed such a mobility chapter, and please correct me if I'm wrong, but I understand that this was the case. And this, so EU proposed to deviate from their free trade agreement practice and to include such self-standing right, but this was rejected, if I understand it well, by the UK. So there is also no commitment for visa-free travel. There is only a provision for a visa-free short-term visits in accordance with domestic laws. So that would depend on the laws of each member state and UK. Instead, mobility rights are enshrined in Title 2 of the TCA, which govern trade in services and investment. That's where you find those mobility rights. Accordingly, in the EU Brexit era, individuals can enjoy mobility rights under the TCA if they are selling, providing, or receiving services or traveling for investment-related purposes only. And it is temporary in nature, of course. The new mobility regime thus again fulfills the government's pledge to end free movement. So this is one conclusion. Now, in terms of the content and scope of mobility provisions through the liberalization of services, the TCA is a very complex document. So I'm only highlighting some of the points here without going into the detailed description. First, there are some differences in trade in services mobility under the TCA and GATS. One such maybe more formalistic difference is that under the TCA, modes 1 and 2 are combined into one mode. This is typical as well for the EU's free trade agreements like CETA and EU-Japan EPA. That is, the TCA's rules on cross-border trade in services covers both situations when the service is being sent, as well as situations when the consumer moves to the other party. Second, there are some differences in terms of the scope of trade and services liberalization under the GATS and are found in the TCA. Actually, I here have a very complex slide of all these different modes. Probably not something that you can follow very deeply, but it just shows each 4 of those modes. Now, one of the differences again with GATS is that GATS follows the so-called positive list approach when it comes to services, under which liberalization rules apply only to the areas and measures that the parties have specifically included in their schedule of commitments. So things that are not included are not liberalized. This makes GATS a rather limited instrument. By contrast, TCA, like CETA, adopts a mixed approach to sectoral limitations. It uses a negative list approach for some modes and a positive list for others. Specifically, the TCA follows a negative list for modes 1 to 3, meaning that all services sectors are covered unless explicitly listed as otherwise in the annexes. But for mobility under mode 4, that is mobility to supply service, a list of permitted activities is provided. So in that sense, mode 4 is similar to what we see under GATS. Now, overall, one could suggest that perhaps TCA mobility rights are then broader because there is this mixed approach, broader under the TCA than what we see under GATS. However, one feature of the TCA is that it contains general carve-outs from the services chapters, such as audiovisual and certain air transport services, but it also provides for numerous mode-specific sectoral limitations, or so-called reservations. And these reservations are listed in a 200-length annexes, for the UK, for EU, and then for individual member states, which makes TCA actually a very complex document to read and to assess the actual scope of its services liberalization. Now, in terms of the content of those mobility rights, here is again, I have those this diagram with the different modes of supply, but on the right side of it, I have categories of persons that are actually covered by the TCA. So, intra-corporate transferees, for example, or contractual service providers, independent professionals, or short-term business visitors. So, mobility under the TCA is limited to these categories of persons, of these service providers. Furthermore, mobility rights for these persons are then subject to a number of conditions. And here I have another very detailed slide, which of course you are not going to read, but this is just to give a flavor of the many conditions that apply then to each of these categories of persons, and they relate to professional status, experience, employment contracts, remuneration arrangements, and so forth and so on. So that is another limitation. And even further then, there are further restrictions which are detailed in the reservations and in the annexes, again, for the UK, EU, and individual member states. So, you know, you can see that you have the limited categories, then you have conditions for these categories of persons, and then further sectoral limitations. And as well, another fundamental difference from the EU free movement regime is that rights of family members are very limited under the TCA and are only available in circumstances to intra-corporate transferees, but not to the other categories. So to sum up, mobility for mode for mobility under the TCA is fundamentally different from the free movement of rights under EU law. So no free movement after Brexit. Any UK national who wishes to work permanently in another EU member state or EU national in the UK will be subject to the national immigration rules, any visas, work permits, and other requirements that national law assesses. And trade and services related mobility is also limited, which bears strong negative implications for certain groups. You have already mentioned musicians in your presentation as well. So this is something that also sort of falls out from the TCA simply because they don't meet all the requirements, or they don't neatly fit into these categories of persons. Perhaps just to end my very sad presentation on a more positive note, the TCA provides for a possibility to improve mobility provisions in the future, for example, by reducing the number of reservations and including other sectors. This, of course, would be a political decision, and only time will tell which direction this will take. So thank you very much.
I thank you very, very much, both of the speakers, for dense. I thought after Todd's presentation, it could not get even denser, but it did.
Sorry.
Deeper, and I appreciate it very much for your excellent and very insightful presentations. It just shows how very difficult it is to master these very complicated and long documents. I would like to open the discussion, hand the floor to the audience. Also, I saw there was someone online. Do you have questions? One question here. Yes, we'll start over there.
Yes, thank you, Martin Reiter from the Austrian Foreign Ministry. Thank you both speakers, very impressive and concise and operative presentations both. My question goes to Professor Told, and it concerns only one of your slides, and it was a very fast succession of slides, but I did think I recognized popping up on one of the latest slides a very old bilateral Austrian-UK treaty from 1925 on the right of establishment that I don't know how it came into the analysis, perhaps in the logic of going back to it, as we see sometimes with discussions with some treaties in the area of judicial cooperation, where previous cooperation has been made impossible by Brexit. You find discussions of possibilities to go back to old pre-existing bilateral treaties. And here's my question. I'm wondering, and this is really a question of a global scope, it doesn't pertain only to right of establishment. Going back to such an old bilateral treaty that existed prior to the existence of the EU, in fact, is in fact possible. If we think of the Vienna Convention on the Law of Treaties, Article 59. It's an old treaty. It existed between two countries. These two countries joined the European Union in different points in time, but at one time they were both members. And it was superseded by the fundamental freedom in the primary treaties. Now, that having happened, now Brexit happens, can that treaty suddenly come back to life? And I would cautiously argue against that, because it's been killed, if you like, by the Article 59 of the Vienna Law of Treaties. But it's really a question. Thank you.
Thank you very much. I believe we had, yes, Matthias Lehmann, Michael Weber, and I think I saw someone else already. Oh.
Thank you very much, Julia, for a fascinating presentation. My question is to you. From what I understood, there is no Austrian legislation regarding a possible transition of what you have called pseudo UK companies. I think of private limited companies, for instance, that are registered in the Companies House in Cardiff and have their activity exclusively in Vienna. There may be such companies, usually with very low volume of transactions. Well, the question is really, should they now be turned all of a sudden into partnerships? A colleague of mine from this house, whom you know well, Chris Tomale, has argued that there would be a principle of vested interests, or vested rights rather, that would be a general principle of conflict of laws, and we should use that to preserve the legal personality, at least for those which existed previously to Brexit. What do you think about that?
Thank you very much to both speakers. I have a very much a connected question to the one that Professor Lehmann just asked to Professor Told, and then one question to Professor Leinarte. Is my understanding correct that there is absolutely no grandfathering of the rights of companies that have been established prior to the end of the transition period? And this is a point of contrast with free movement of persons. And if so, what are reasons? I mean, are there economic reasons, such as the desire of EU member states such as Ireland and the Netherlands to attract British companies, or is it something else? And my question to Professor Leinarte, is there work that has tried to disentangle the effects in terms of the contribution to the fall in the net inward migration in the UK, so withdrawal from the European Union on the one hand and the pandemic on the other? Thank you.
Thank you very much. Let's have a first round of answers and collect questions afterwards.
May I start here?
Yes, please, Julia.
Okay, I want to start with the first question. Thank you very much for the very well thought through question addressing this mutual agreement or trade agreement between the UK and Austria dating from 1925. Obviously, it is still in force. And I don't know if it might have been replaced. That basically came to my mind by the European Union and the treaties going from there, and then possibly also the exit treaty and now the trade and cooperation agreement. But the fun thing is that it's still it's still set to be in force, and it has been a bilateral agreement that does not necessarily have to be replaced by an agreement that's not only concluded between the UK and Austria. But obviously, there's a good point on your side that the Austrian Supreme Court, when deciding on the latest private international law cases with respect to UK companies having their legal seat in Austria, did not even consider that treaty. But Professor Bachner from the Vienna University of Business Administration and Economics referred to that treaty And he comes to the conclusion that Article 15 of that treaty would grant a mutual recognition clause that overrides national, private, international law regimes. But I totally agree that it somehow contradicts the trade and cooperation agreement. So you could argue that the latter treaty has somehow derogated the more previous one. And I have not entirely thought that through, to be really honest. I like your perspective, but the thing is, it could be a thing if you have a member state of the European Union that follows the real seat theory to ask maybe there is a bilateral trade agreement that recognizes the companies from the other party to the agreement. And we have a trade agreement with the UK. It dates from 1925. And it's still in force. At least that's what the Austrian Ries says. Obviously, it could be derogated, and I see the point, but it could make sense to look to have a closer look at those treaties as well. That's basically the point I wanted to make. But I totally get why you are not entirely convinced here. Then I have like the Professor Lehmann that refers to crystal Mahler, that refers, who refers, I think, to Article 6 or 7, this vested rights provision. Well, it's true. I have great sympathy for that position. I also have great sympathy for the position of Georg Eckert, who basically said we have to treat those companies as companies in liquidation, which means they at least have legal personality, and we do not kill them or transpose them into a partnership. So I totally get that. We have to recognize that the Austrian Supreme Court did not apply the theory of Professor Eckert, and he also did not reflect on any vested rights before the exit, and he did not refer to Article 6 or 7, I don't know, of the Austrian Private International Law Code. I have great sympathy for that, and especially Professor Bachner has referred to another decision of the Austrian Supreme Court that was dealing with actually a shareholder and of an Austrian company, and the shareholder was a UK company that was kicked off the company registry in the UK, and the question was, who is the owner of the share with respect to the Austrian limited company. And since it all goes to the Crown in the UK, if the property lays within the UK, it did not cover a share in an Austrian company, and suddenly the Austrian High Court had to answer the question, who is the owner of that share? And in this very situation, he actually invented some kind of a legal personality, and we have a case that did that, but it's a different one, because it's just like it's a property that needs to be somebody's property in Austria. And the fun fact in this case was that the UK basically ripped off the company register, the company, which meant it loses its legal personality. So there was no legal personality, but there was some kind of property or some kind of assets in Austria, and we needed a legal personality. Maybe we could work from there. I don't think that the Austrian Supreme Court would apply any rule of vested rights, but of course I have sympathy for that, and I have sympathy as well for the solution of Professor Eckert, who wants to treat them as a company in liquidation. Yes. And is there any rule of grandfathering? It's basically this questions comes from the same perspective. Do we grant UK companies limits that the legal personality of which we once have recognized due to the freedom of establishment, and if we have once recognized their legal status as being a foreign UK company, why couldn't we continue to doing so? I absolutely see that we frustrate the expectation of shareholders that think they are shareholders to a company with limited liability, and finally they face personal liability. And I see all those problems, but from an academic perspective, I have sympathy for all the solutions that prevent them of facing personal liability, but I doubt that the Austrian Supreme Court would follow those positions. He didn't in the very last case that concerned a UK pseudo-UK company with only one shareholder. And what the Austrian Supreme Court does, he applies section 142 of the Austrian Business Code per analogiam, which means the shareholder, the sole shareholders, is the universal successor of the company, and basically the court continues the proceeding after rectifying the parties to the proceedings. Yes, and I don't think that we will see a change in the national in national case law. I would say this. We don't see a change in Germany as well. I do not know how they deal with those cases in Greece and in France, but I would be very interested to dig deeper on those questions. Did I leave out any question?
Thank you, Dr. Leinarte.
So the question, just to remind, was about the correlation of the effects on migration coming from Brexit and COVID, right? I know that generally the disentangling COVID from Brexit is something that is very much part of the discourse in the UK. I know that there is a lot of work being done to try to figure out what are actually, especially in the trade context. One of the biggest think tanks on Brexit in UK, EU in a changing UK in a changing Europe. That work is being done there as well. And my colleague, Catherine Bernard, is working on very large projects on the immigration and Brexit aspects. But I would have to check with her more precisely if some empirical research has been done to actually provide the numbers and to understand really the effects. And that would be very interesting. And I'm sure that there will be more and more of this research. We are just kind of coming out of it. Yeah, that would be my less informed answer, I think.
All right, thank you. We have one more question online, which Johannes will be so kind to read out. Then we have a question here from the audience from Michelle Everson, and I would also like to add a final question and then wrap this up.
Yes, we have even two questions actually from online. Both are from Madame Emilija. The first question is to Professor Told. Madame Emilija asks, she's wondering if there are any signs of parties using Maltese or Irish law instead of UK law post-Brexit. Are we seeing an increase in Maltese or Irish companies using another EU member state as their main seat of operation? And the question to Professor Leinarte, sorry, is, one second. Do we know how UK citizens who are residing in the EU have been integrated into their countries of residence post-Brexit? Thank you.
Thank you.
Yes, I think quite similar to that last one, and the question for Professor Leinarte. From personal experience, because I'm a cross-border citizen, so I qualify as a UK citizen under the withdrawal agreement, though I'm also German, but I'm a cross-border citizen into the UK. The grind, the sheer administrative grind of living a life now, just to get health insurance confirmation. I don't know, out of the British authorities, you know, a simple letter takes 18 months to be answered to. And I mean, I assume this is for everyone. This is for the cross-border situation is a bit complex because you've got the social security and everything involved in it. But generally, it would surprise me if firms, if people aren't all being faced with this complete grind. Are there any moves afoot to maybe have a right of administrative ease? For whether it be the British in Europe or the Europe in Britain, because this is just, I mean, it's just you get to the point where you want to give up after a, after a certain period. So that's my question. Bit self-interested.
Thank you. We had a last minute question next to you, Dr.
I would
Noj.
like to ask you, how can we the data protection through the digital single pre-establishment on the single market? How the date protection
Right.
through this pre-establishment in the
This-
press, for example?
All right, thank you. Did I overlook anyone who wanted to ask a question? No. Okay, then maybe if I may, just very brief final question, and then I'll wrap up the panel and hand the floor back to you. If it goes to Dr. Leinarte, if I understood you correctly, you said there is direct, or you assume that the withdrawal agreement is directly applicable. Could you clarify more how you argue that? Because there is also the spirit that the ECJ for international agreements always takes into account. So it's not self-evident that it would be directly applicable. And would you distinguish the withdrawal agreement from the TCA in that regard, or would that run in parallel? And if there is direct applicability, is my understanding correct that the withdrawal agreement via preliminary reference procedure is indefinitely under the control of the ECJ? Then how is the court system for the TCA? Is there also enforceability, or how is that handled? And the last aspect, direct applicability, is that the same then from the UK perspective?
Yes.
Okay. Thank you. So the floor is both of you open to both. Probably Dr. Leinarte first.
So maybe just I don't know in which order I'll start. In terms of enforcement of withdrawal agreement and TCA, and thank you for asking that, because it's a very important point. These are essentially different agreements. If I go back to, oh no, I can't go back to, sorry, else I'll switch off the wonderful speaker. No, just the scheme that I had, the withdrawal agreement, of course, has different avenues. There's arbitration regime, but then there is also this, as I said, these different routes to go through the ECJ preliminary reference procedure. That is an indefinite route coming from questions from the arbitration panel, right? So UK can bring it, it's a complex system. UK can bring for the 8 years preliminary references. That's not an indefinite right. The arbitration can bring indefinite time, and of course member states indefinite time. So different rules for different actors. Direct effect of the withdrawal agreement is for the citizens' rights only. So it's not the entire withdrawal agreement, the citizens' rights part of the withdrawal agreement. Now, what I find personally very interesting, as this relates very closely to my doctoral studies, is that TCA is an EU-only agreement, and as you have mentioned, there was not much talk about it being a mixed agreement. Even though I find that particular point quite interesting, because TCA foresees in the future conclusion of future agreements. So now this is an EU agreement that will have other agreements as part of it, but all of this now is predetermined. It will be an EU-only agreement. Anyways, this is another topic. But in terms of enforcement of these mobility provisions, it means, first of all, it's a very similar dispute resolution mechanism that what we have under the WTO. So you enforce mobility rights in a state-to-state only arbitration mechanism. This is number one, but this is already quite interesting, right? But another point is that the TCA being an EU-only agreement, there is a major difference between the WTO. In the WTO, you can bring a claim against the member state, but you cannot bring a claim against the member state under the TCA. And of course, we know that there is this sincere cooperation and the, member states follow with it, but legally speaking, there is no route to actually bring a claim against the member states under the TCA for violations, for example, of mobility provisions. So this is one group of questions that I have, and maybe in the future, because everybody, of course, always assumes that this is not a problem because let's look at the WTO. In the WTO, it's always the European Union that represents the member states, but actually that's not really the case. There are many cases in the WTO where claims have been brought directly against the member states for violations of the WTO agreement, and this would not be possible under the TCA. So this is one point. Data protection has not been included in the TCA, as you have mentioned. I understand that there are all these talks about the equivalency of the data protection, and I just recently read that the French, Commission authorities went to the UK and then were horrified by the rules that they are not, they are not focused on fundamental rights. So there is now this whole debate on whether this equivalency will be granted, but I'm not an expert on that part. And yes, and that particular question that you have, I have it myself. I'm almost a cross-border person, but of course with a settled status, so things are simple. But I know a lot of people who are experiencing all of that administrative burden, and I understand that the route to solve that for these solutions is, again, independent monitoring authority and all of those things, but how effective they will be probably will be clear only. Now there's litigation, right? We already see litigation coming and for different types of rights, but I guess we'll see how this goes.
Thank you very much. And finally, Professor Told.
Thank you. I love your question, Eva, as I love seeing you here, but I can't answer it because I did not conduct any imperial studies, so I do not know if we see more Irish or Maltese companies being created compared to UK ones. So I really don't have an answer to that. But if you know, I would love to hear from your perspective, because I have no idea, but would love to have an answer to your question.
Please just turn on your microphone if you did you wish to react?
No, I don't have the answer either, but I suspect that there's going to be some movement.
Yes, I see that too, but I have no empirical data, and I did not see anything there.
And the other point I was going to say, I feel very sorry for British citizens who live in Europe, and many of whom lived in Europe for so long, to not have had a right to vote on the Brexit question. And they're also kind of left out of the discussion to some extent. So there's a little bit of a problem there. That's why I asked my question. But anyway, I won't keep you. I've got my slot tomorrow.
All right. Thank you so much to the speakers again, to the interveners, to everyone. I'm closing this panel, and I feel very bad because we're lagging behind times. We should have started the fourth panel 3 minutes or a couple of minutes ago. Still, I look at the chair of the next panel for permission to have a coffee break. How about 20 minutes? You tell me when we reconvene. Is it 50, 45? Okay. All right. So we reconvene at 3:50 p.m. Thank you, everybody.
Thank you for having me. Bye.